Many people ask me about Section 245I. 245I was a law that was enacted in 1994 to be precise, and at that time it was a penalty that people paid for being illegal in the United States. The law was from 1994 to 1998, if you were illegally in the United States and wanted to adjust your status, you could apply for adjustment of status by paying a penalty of $600. That penalty was increased in the year 1998 and was raised to $1,000. And that law extended under Bill Clinton till April 30th, 2001. And basically what it is if you're in the United States illegally and you want to change your status and you are getting a green card in any other way aside from an immediate relative, you can't if you are illegally here or if you've entered the US illegally. So what they did in 1994 was instead of making you go back home to your consulate, Congress permitted you to go ahead and apply for your green card by paying a penalty of $1,000. So for individuals who want to get a green card through work but they're illegally here, or individuals who are married to a green card holder and want to apply for a green card and their spouse for some reason is not eligible for citizenship or never can get citizenship, then those people, if they were covered under 245I, were eligible to adjust status in the United States. And there are other categories as well, if you're not an immediate relative, that would permit you to get a green card pursuant to 245I. That law ended April 30th, 2001. And depending on when your application was filed, so if it was a family-based petition or a labor certification petition, if it was filed before 1998, then all you would have to do is pay the penalty. If it was filed between January 14th, 1998 and April 30th, 2001, you would have to pay the penalty, but also demonstrate that you were physically present in the United States on December 21st, 2000. In addition, now immigration has been very careful to make sure that the application was a bona fide application. And so in order for it to be a bona fide application, if it's based on a family-based petition, they want to see that that was a real relationship. And it couldn't be a petition that wasn't legal under the immigration law. So for example, under immigration law, an aunt can't file for their niece for a green card. If your aunt filed for an I-130 family-based petition for you and you're the niece, you're not going to be covered under 245I. But if you are in a family-based category that was legal, such as a spouse, parent, or child, then you're going to be covered under 245I if it was filed prior to April 30th, 2001. In addition, if it's a family-based petition, but it was denied because they didn't believe the marriage was real, then you're going to run into trouble as to whether or not that was a bona fide application, and you may not be covered under 245I. You also can use 245I if you filed an application through employment prior to April 30th, 2001. And in fact, when we knew the law was ending in April 2001, people rushed to file applications. And immigration has said that you're allowed to use that filing, the 245I filing, even if the case was denied, withdrawn, or revoked. And so any of those valid applications might still be viable for you to use now. If the immigration doesn't believe that it was a bona fide job offer, if it was an employment-based context, then they might not agree to approve your case, saying that you're not eligible under 245I. They are scrutinizing these cases carefully, so you want to make sure that you have evidence that your application that was filed before April 30, 2001 is still viable. The beauty of 245I is, even if you had been sponsored many years ago through employment or marriage or another family-based case that never went anywhere because the employer decided they didn't want to continue with the case, or the company shut down, or your relationship ended, if you have that old petition, we call it grandfathering, and that petition will allow you to apply for a green card based on a new petition if you're eligible for something else. So if you remarry a United States citizen, or you have a company now that wants to sponsor you for a green card, and it's a completely new company that sponsored you in 2000, you're eligible to use that old filing to apply for a new green card, and you would pay the penalty of $1,000. It's a good way to legalize your status in the United States if you have no other way to be here because you entered the United States illegally, or you want to get a green card through employment. 245I can be complicated. It's important to also know your family history, because if your parents were grandfathered under 245I and you were eligible as a child, you were under 21, you still might be covered under 245I. If you were married to somebody who was covered under 245I, even if you were divorced, you also would be covered under 245I. But it's important to go over those questions with an immigration lawyer. Lawyers who ask you a lot of questions about your family, your marital history, they're not doing it because they're nosy. A lot of times we want to figure out if you're 245I and could get a green card some other way in the future. If you have questions, or if you want to know whether or not you're covered under 245I, or you think 245I can help you apply for a green card in the future, please contact my office and I'd be happy to go through those questions with you and discover whether or not you're eligible for a green card now.